Good morning. It's Wednesday, 27th of May at 10:30 a.m. Welcome to the Migrant Law Clinic. My name is Dr. Chelvan. I'm a barrister at number 5 Barristers Chambers in the Immigration Group. I'm co-hosting this morning's seminar with Rushe and Jake Rylatt.
Good morning, everyone, and welcome to the webinar. Hopefully in advance you will have been sent the slides. We're hoping the technology gods will shine on us today. I, of course, am also a barrister at number 5 Chambers in the Immigration Law Group.
Thanks, Avril, and good morning. My name's Jake Rylatt. I'm also a barrister here at number 5 Chambers as a part of the Immigration Law Group. Now, many of you have already kindly sent in questions, and during the webinar, we're going to try and answer some of those questions within our presentation, but please do continue to send in any questions through the chat room box, and we will try and answer them at the end, the chat room box being at the bottom of your screen.
So, the title of this morning's webinar is Asylum and Human Rights, Law, Policy and Practice. What we hope today is to explore new approaches and new avenues in relation to migrant protection for those of us who represent migrants and those of us who are migrants in the UK seeking leave to remain or entry clearance. But we're living in uncertain times with COVID in the UK having nearly 40,000 people having succumbed to the coronavirus. And one of those people was the late Sir John Laws. This is Sir John Laws on my call night at Inner Temple on the 14th of October, 1999. I'd first heard Sir John speak at the University of Southampton, where I was an undergrad, 2 years earlier in 1997, where he gave the Gabriel Gans public law lecture and talked about the limitation of human rights. But in that lecture, to that student who's an eager human rights activist, what I heard is those swords and shields could be used to empower migrants and make sure that individuals took the state to account. Because we know, and on behalf of those of us who are presenting the webinar, we'd like to dedicate the webinar today to the memory of Sir John. Because we know in the world it's a very dangerous place in relation to marginalised groups. And here, for example, we have a report from Pink News on the 27th of March, talking about how the coronavirus is being used to blame marginalised groups, especially trans and lesbian people in Ghana. If you look at the Home Office SIPIN on Ghana, it says quite clearly there's a lack of evidence regarding risk to lesbians and trans people. But here we have evidence as recent as the 27th of March showing that these individuals are at risk. So this morning, we're going to look at 4 specific areas. I'll be covering the issue of protection, specifically new pathways to protection, and the nexus between criminal deportations and asylum claims, policy changes with the Home Office with respect to country of origin information, and impending and recent country guidance developments.
And I'll be looking at the landmark judgment of the Supreme Court in AM Zimbabwe and its implications for Article 3 medical treatment cases.
And then I'm going to take over and I'm going to provide a run through of the recent case law on Article 8 of the ECHR, both in the context of applications to enter and remain in the UK, but also in relation to deportation claims.
And within our presentations, we'll be looking at some issues regarding practice and procedure. And at the end of the presentation, looking specifically at current issues in the upper tribunal and the first tier tribunal. Now, if those of you who are using social media, please don't hesitate to tweet about the webinar. We're using the hashtag Migrant Law Clinic, and those are various Twitter handles. We are recording the webinar this morning, and that will be broadcast on the number 5 Chambers website in a few weeks. We will unfortunately be running slightly over the hour. We apologise for that, but we've got a lot to share this morning with you regarding our areas in relation to what exactly is going on in relation to future developments. There is a section in my presentation which may be called some sensitivity in relation to various issues. I will provide a warning before that material is shared on the webinar. Now, number 5 Chambers Immigration Group, Avril and Jake, what are your 3 favourite words?
I think Don't Stop Believing is good. Great song and good message for life.
Equally cheesy, but equally true. When it comes from the first tier tribunal, I think it has to be appeal is allowed.
Okay, I love Avril's reference to the Journey song, but I sort of prefer the Glee rendition. Avril, if you don't know, is a fantastic singer, and she has her own band called Alpaca Redemption. So please go and buy her records. Yeah, checks in the post, I hope. I can do a fantastic rendition of all 7 verses of Kumbaya after various glasses of wine, but I won't share that with you today. So what are my 3 favourite words? My 3 favourite words is the Francis Bacon Thomas Hobbes quote, "Knowledge is power." Now, a lot of webinars you'll see about reactions to cases, looking at case law developments and reacting to how we are supposed to litigate following these cases within the upper tribunal or higher courts. And clearly we're going to be doing that this morning with respect to AM Zimbabwe and the Article 8 developments. But what we wanted to do this morning is also look at different pathways in relation to protection, which may have not been litigated before, because we're going to be using this time during this lockdown to be able to think about how to best represent our clients. So let's look at protection claims. Now, clearly Brexit's going to come up, and a lot of you would have received the PowerPoint slides. Do note that the sections highlighted in blue actually have in your PDFs hyperlinks to the resources online. So we know under section 2, following exit day on the 31st of January 2020, because the international protection regulations are cited within the immigration rules, they are still our law. Until completion day on the 31st of December 2020, Luxembourg court decisions are binding. So really no change as of yet in relation to post-Brexit. Now we go back to the 51 Convention and we know the definition, but let's go back to the text of it. Well-founded fear, looking at those issues in relation to the subjective and the objective. What we're going to concentrate on this morning are the 5 Convention's reasons: race, religion, nationality, membership of a particular social group, or political opinion. And we're going to look at how they intersect, but we're not just going to look at the intersects between the Convention reasons, but within the Convention reasons, between actual and imputed. And what I'm interested in is the focus of the imputed. Look at the views of the persecutor. Because why does the persecutor persecute the migrant, the refugee? Because of their non-conformity, their lack of conformity with the profile the persecutor would wish them to adhere to ensure that they conform to the standards, the religious, social, cultural standards of the persecutor. Because it's this difference which gives rise to the persecution. For example, all of you who would listen to my LGBT plus seminars would have heard about the LGBT plus, lesbian, gay, bisexual, transgender. There's a spectrum of terminology. But the issue is not that they're LGBT plus, but they're not straight enough. They do not conform. Now, when you go back to the issues in relation to the definitions, go back to the definitions within what makes the Convention reason, and under particular social group, for all the groups within the particular social group, is because they're considered different. Look at the underlined section in that PowerPoint slide, as being different by the surrounding society. And under 10.2, under the imputed definition, it's immaterial whether the applicant actually possesses a characteristic, provided it is attributed to them by the actor of persecution. Question for Abu Sayyam, which was sent before the seminar this morning. In a forced marriage asylum case, does a victim need to have forcibly been married to an actor of persecution, or will a fear of subjected to forced marriage suffice? LH and IP, one of the only paragraphs which I still think has force, following the fact that we do now know that there are prosecutions of gay men in Sri Lanka, the Galabada judgment in 2016. So paragraph 119, the upper tribunal accept that forced marriage could lead to a fear of persecution. So it doesn't actually have to have happened, it is the fear of. What the upper tribunal focus on is the availability of internal relocation. But in my view, it's the issue of the lack of conformity to evade persecution. So to answer Abu's question, it doesn't actually, the forced marriage doesn't have to have happened. It's the fear of the forced marriage which is pivotal. Because this is what really occurs within the refugee framework, the issue of current identity and future risk. The individual refugee does not have to have suffered past persecution to be able to obtain refugee status, and that's very important. So see the seminal case of NR Jamaica, 2009, which is a case of mine regarding a lesbian from Jamaica. Importantly, for any human rights lawyer, it's a badge of honour the first time you get reported by the Daily Mail. And this was the case where I first got reported by the Daily Mail. And the Court of Appeal made it quite clear. It is all about current identity and future risk. Now, when we're looking at the Refugee Convention claims, we're looking at, in effect, two asylum claims. The asylum claim one is the 8J Iran asylum claim under paragraph 82 of Lord Rogers' guidance in 8J. The first limb being prove is or perceived to be within the convention reason. That is the battleground in relation to credibility for all asylum claims, but not determinative in relation to a lack of past persecution. Limb 2, do open members of the convention reason group face a well-founded fear of persecution? That's purely objective in light of the country information. And then limbs 3 to 4, conduct-based. We're not going to cover that this morning. That will be covered in hopefully a future webinar. We're going to look at the first two limbs this morning. Limb 2, as I said, those who lived openly. The Supreme Court in 8J Iran made it quite clear that in a country where there is persecution, very few martyrs, because if you are open, if you are identified due to your nonconformity, you face persecution. Now, in the second asylum claim, this is where the individual risk assessment occurs. So in the case of LZ Zimbabwe, the country guidance case of 2011, January, the upper tribunal found that the LGBT community in Zimbabwe didn't have a general risk. Now, that was the wrong test. When you reread the determination, they actually cite at paragraph 111, the case did not relate to those who are open. So how can it be a country guidance case? But importantly, what it found is that because of the specific profile of the lesbian in that case, due to her family connections with the Zimbabwe elite, that put her in a risk category. That's why her asylum claim was allowed. So, for example, if the individual does have an outstanding arrest warrant or a summons, then that places the individual in the asylum claim too, because you're looking at individual risk factors, not in relation to risk factors of the group as per 8J Iran. So limb 1, they have to prove that they are or will be perceived to be within the convention reason. So it's purely a credibility and plausibility assessment. Note a lack of past persecution. Past persecution is not required to enable a refugee status. So all we're looking at is inclusion in actual or imputed convention reason. Let's look at political opinion, going back to the regulations, the international protection regulations, to include the holding of opinion, thought or belief. So how does that individual express that thought or belief on a matter related to the potential actors of persecution? That's regulation 6.1. So in RT Zimbabwe, the seminal Supreme Court on political opinion, this was in relation to the militia gangs in Zimbabwe at the time, which required the individual to produce a ZANU PF card or sing the latest campaign ZANU song to be able to prove allegiance with the state. The Supreme Court importantly said that not only is there a right to hold a political opinion, there also is a right not to hold a political opinion. And that's very important. And that gives the nexus towards the imputed political opinion. So limb 1, do they have or do they not have a political or imputed opinion against the views of the potential persecutor? So, for example, with those campaign songs, with those protesters, what happens to those individuals, those protesters, if they protested openly on return to Zimbabwe? Will they protest on return? If they won't protest on return, why not? If that's due to a fear of well-founded fear of persecution, they are a refugee. So, for example, this is the updated LGBT flag. It's intersectional. It now has the brown and black stripes and the trans stripes as well. Can you imagine holding that flag in St. Petersburg or Moscow? Well, clearly the individual will be arrested under the anti-propaganda laws, which are used to subject prosecution and persecution of the LGBT community in Russia. For example, the Hong Kong protesters right now protesting with their flags being targeted by the Chinese authorities in Hong Kong. It's all about the expression of that political opinion in the open in the country of origin. Now, in recent country guidance cases, we've had the Iraq country guidance case, which is really helpful in relation to that. In December 2019, the upper tribunal promulgated this case and accepted that a risk category in Iraq with respect to return was those not conforming to Islamic mores. So it quite clearly looked through the prism of imputed to show that the LGBT community in Iraq would also be a risk category in relation to Iraq. Now let's look at the Afghanistan country guidance case. The last hearing before the upper tribunal in that case was the 14th of January. Now, there's also the pending case of Sri Lanka. We'll be visiting that in a few moments, and that's going to be heard from the 22nd to the 26th of June. So, a question from Rafet Hussain: how will the new AS Afghanistan 2020 case affect Afghan cases? Well, we look at paragraph 253, Roman numeral 4. It's all about individual risk assessment. It's quite interesting. It actually accepts that you could assess somebody with physical and mental health issues, issues with language, education, vocational skills, with looking at whether they fall within the general proposition of exception to risk. So it's very much an individual risk analysis. Or is it? On the 24th of February 2020, after the hearing on the 14th of January, but before the promulgation of the country guidance case on the 1st of May, the Home Office published a new country policy and information note on sexual orientation and gender identity or expression. Now, within that policy note, at paragraph 2.4.19, there is the 2009 country guidance case on LGBTs to Afghanistan called AJ Risk to Homosexuals Afghanistan. In that 2009 case, the position was that LGBT individuals could relocate to Kabul as long as they didn't cause public outrage. The SIP-in prior to the February 2020 SIP-in was January 2017, and it continued to repeat the mantra in AJ Risk to Homosexuals Afghanistan that you would not be a risk if you did not cause to seek public outrage. For the first time on the 24th of February 2020, 2 weeks after I submitted the independent review to the IGCI, the Home Office published this, there's clearly no causal connection, the Home Office published this new policy instruction to accept that since the Supreme Court case in July 2010, when you reread AJ Afghanistan 2009, then it accepts that the reasoning of the tribunal to say that it would be, in effect, reasonably tolerable to relocate to Kabul can no longer stand. So the Home Office now accepts from the 24th of February 2020 that LGBTs can be at risk. The question is, why did the Home Office not inform the upper tribunal in AS that they now accepted another risk group? You see in the head note to AS, they refer to various cases not being disturbed because of the reasoning in the most recent country guidance case. But importantly, to any of you who represent or work with LGBT plus asylum seekers from Afghanistan who failed because they've relied on the reasoning in AJ Afghanistan and say that Kabul would be safe, you have now the gatekeeper to the fresh claim. Now, actual or political imputed opinions are Tamil. I make no bones about it. I'm a Tamil. I was born in Sri Lanka. My family came over here in 1978 after the anti-Tamil riots in Colombo in 1977. Now, this is a new country policy and information note on Sri Lanka published on the 12th of May 2020. Within this large document, it goes through various claims, but this is what I'm really interested in this morning. It looks at the issues of demonstrators. 2.4.33. Now, if you look at 2.4.34, it looks at the issues to risk to demonstrators on return to Sri Lanka. And there's a specific section which I'd like us to concentrate on this morning. So the question to be addressed is whether such membership is likely to be detected on return and or whether or not the person's activities in the UK are or will be perceived to be a threat to the integrity of the state. And if so, they will be subject to legitimate prosecution rather than persecution. Now, the question is, how does that fit into the HA guidelines? It's axiomatic from that paragraph that, in effect, it accepts that those people who demonstrate outside the Sri Lankan High Commission or outside Westminster have a genuine political opinion. So the next question to be asked under the HA guidance is what happens to those who protest openly? We can see from the country information, the International Truth and Justice Project and the Journalists for Democracy in Sri Lanka published this press release on the 30th of January, talking about 69 disappearances during and after the November 2019 presidential election. So the situation, what would happen to people who openly protest in Sri Lanka? Now, I'm going to give the warning here because I'm now going to use an educational tool to illustrate the point. Please note that what I'm about to do does not necessarily reflect the political views of myself, and it is not reflective of the views of my co-hosts or the immigration team or number 5 barristers' chambers. So what happens, it's a Tamil Elam flag held by those protesters outside those protests in the UK. So what happens if I hold this flag here in the UK? Well, we know exactly what happens to individuals who hold the flag in the UK. Because this is, for example, is a protest outside the Sri Lankan High Commission on the 4th of February 2018, holding the flags outside the Sri Lankan High Commission. What happened on that specific day? Well, we have Brigadier Fernando standing outside the building using the cutthroat sign in relation to those protesters outside the Sri Lankan High Commission. And what happened to him? He was prosecuted here by the authorities, and I'd recommend to all to go and read the judgment of the Chief Magistrate, Emma Arbud, which looked at the prosecution and convicted him under sections 4A and 5 of the Public Order Act. Now, the defence of the Brigadier, as he then was, and we now know that in the last week he's been promoted to a Major General by the new President Rajapaksa, that he was prosecuted, but his defence was impunity. He didn't say anything about the fact that he wanted to give a threat of violence to these individuals. It was an issue of impunity. Now, so for example, if the Sri Lankan state uses cutthroat to show violence to protesters in the UK, just imagine what would happen to individuals in Sri Lanka. So when I'm looking at litigating cases, Tamil cases here, for refugee status in the UK, is by holding that political opinion, knowing that those protesters actually genuinely hold that opinion, and that's not disputed by the Home Office in their SIP-in. So what would happen to them if they openly protested in Colombo? We know what would happen to them if they openly protested in Colombo. They would suffer persecution. So the question here is not what would happen to them, whether they have a summons or an arrest warrant, or whether the authorities know about their activities in the UK, but what would happen to them if they openly protested in Sri Lanka? And then the question is then, well, why would they protest in Sri Lanka openly? If not, why not? And if it's a fear of persecution, then they're a refugee. Imputed convention reasons, I've been doing a lot of litigation in relation to these cases since 2005. The most recent case is SW Jamaica in 2011, where the upper tribunal accepted that even straight women in Jamaica can be perceived to be lesbian if they do not accept the sexual advances of the potential persecutor. In Jamaica, women have to be sexually receptive from 16 to 60, and unless they have a male partner, children, or recent evidence of a widowhood, if they're not receptive, they could have a real risk of curative rape or murder. In 2005, in relation to the country guidance case, which is still in force in relation to gay men in Jamaica, the tribunal accepted that there was force in the submission. That perception is key. Now, let's look at criminal deportation cases from Jamaica. Now, when we're looking at what happens on return to Jamaica, we have one of the most recent guidance was the FCO guidance 2015, coming home to Jamaica. Now, what did the Foreign and Commonwealth Office advise those who are being deported from the UK to Jamaica to do? Well, in this booklet called Coming Home to Jamaica, you see those bullet points of what they should do. This is the UK government informing Jamaican deportees what they should do on return. And you look at the fourth tick. Try to be Jamaican. Use local accents and dialect. Overseas accents can attract unwanted attention. So in effect, it's axiomatic that it accepts that if you can't prove Jamaican, that because of your accent, you could be viewed as another nationality, there could be real risk. And this is Diane Taylor's article in The Guardian last year, which talked about 5 men killed following deportation in the UK. So one of the tools which I'm using in litigation is using the nexus in relation to risk on return and imputed nationality. What about political opinion? A lot of our clients fear that when they return, it's the issues of gang culture. Now, Gomez is a very long established case, one of the key cases in imputed political opinion. And what Gomez says, that case of a Colombian national and the FARC guerrillas, was that when you look at non-state agents, if you don't adhere to the rules of the gang, then that in effect could be political or imputed political. Now, the most recent country guidance case in relation to criminal gangs in Jamaica is 2007, AB protection claims. But that case only looked at through the prism of gender, because the appellant was a woman and feared harm because of her gender and fear as a part of her family. But what hasn't been considered is the added limb of imputed political opinion or political opinion. So that's another way of a new pathway in relation to protection. So in effect, what we're trying to be able to do here today is look at alternative pathways in relation to refugee status to hopefully reach the summit to sanctuary. So Avril, you're now going to cover AM Zimbabwe.
Yes, thank you, Chelvan. I'll just share my screen with you. So AM Zimbabwe, as we know, just came out over just about a month ago. And it really is a landmark judgment, so bringing our domestic law in line with the ECHR jurisprudence. Now, it relates to when a removal would amount to a breach of Article 3, especially in circumstances where in the country of origin medical treatment is lacking. Now, Lord Wilson, giving the lead judgment in AM Zimbabwe, he was very clear that this was a difficult question for the Supreme Court to grapple with, one of the most controversial questions which the law of human rights can generate. And really what we're looking at is the pitting of a state's sovereign right to control the entry, residence and expulsion of aliens against Article 3. And he stated that it would be a heavy burden to lie on the court. Now, let us remember where what the factual circumstances of AM Zimbabwe were. It was a man who was HIV positive. He was not able to access the specific medication which he required in Zimbabwe. Now, this would mean that in practice, his CD4 blood count would fall, he would relapse into AIDS and would be susceptible to certain illnesses. Now, this would likely have led to his death. Initially, he brought the case under Article 8 because at the time, Article 3 would not have yielded any success due to the N judgment. However, Papashvili was promulgated by the European Court of Human Rights, and Mr. AM decided that he would then try and bring the case under Article 3. Now, of course, the Court of Appeal was bound by the House of Lords decision in N, and the Supreme Court was then asked to depart from the N judgment and to remit the application for rehearing with reference to Article 3. The line of case law we've come through is important to just have a quick look at. So we started the case of D. Now, in that case, we had a man who was at a very advanced stage of his illness. Also, it was HIV. In that case, the ECHR found that there was a breach of Article 3. However, it was the inhumanity of pulling a man off his deathbed, as Lord Wilson noted in AM Zimbabwe, rather than the question that later came up in N. Now, D stated that the test was there would have to be very exceptional circumstances. N's case was not a man who was about to die with dignity, but rather a person who wished to live. This lady's life expectancy was going to be reduced from a few decades to a couple of years if returned to Uganda. Now, unfortunately, the House of Lords found that there was no breach, but they did express unease with this. Lady Hale found that the test had to be that a person would have to be able to return to face their death with dignity. Otherwise, they would be deprived of treatment which was not contrary to Article 3. And Lord Brown found it difficult to find the distinction between a person who was facing imminent death and a person who would have their life expectancy so significantly reduced. Now, in the European Court of Human Rights, the decision of the House of Lords was upheld. Again, they reiterated the D test. There may be other very exceptional cases in which the humanitarian considerations are equally compelling, but this case, the N case, was not considered to be so. Now, during the judgment, they did mention that allowing a case such as N's to be a breach of Article 3 would place too great a burden on contracting states. Now, of course, what that does sound like is policy considerations being brought into the Article 3 consideration. And in the dissenting judgment of Tolkien, Bonello and Spielman, they did address this point. And it was really a trenchant dissenting judgment. And they looked at the non-derogable character of Article 3. So it's absolute. There's no balancing exercise like in Article 8. And so it's a lower standard to meet than Article 8. They found that the majority had added very worrying policy considerations based on an incomplete statement that essentially the convention is about the protection of civil and political rights only. They also looked at the budgetary constraints and resource considerations, which the majority seemed to have taken into account, and said that this runs counter to the absolute nature of Article 3. In their opinion, this was a case of exceptional gravity, and it ought to have met the D test of very exceptional circumstances. Fast forward to the case against Belgium, where we had similar facts to N, again a concurring opinion of six of the seven judges, who expressed their opinion that hopefully in the future the court might review its case law in relation to this Article 3 standard. They found that requiring that a person be nearing death was hardly consistent with the letter and the spirit of Article 3. And then came the case that really changed everything on the ECHR level, Papshevili and Belgium. Papshevili was a citizen of Georgia. He'd been settled in Belgium. He was married with 3 children. He had been suffering from a chronic form of leukemia for 10 years and had received extensive therapy. In the end, one particular treatment was going to offer him the only prospect of cure, a certain drug that would then allow him to stabilize and receive a donor blood stem cell transplant. The medical opinion expressed in the case was that if he were not to receive this treatment, he would likely die within 6 months. And unfortunately, Mr. Papshevili did die before the Grand Chamber promulgated its judgment. But owing to the importance of this issue, they continued nonetheless. They stated that the approach to Article 3 had to be clarified. There's been a lot of talk as to whether this was actually the correct word to use, as it wasn't so much clarified as really changed. It had evolved along in line with the living instrument doctrine of the ECHR. They said the very exceptional cases test set down in D should be understood to refer to the removal of a seriously ill person in which substantial grounds have been shown for believing that he or she, although not at imminent risk of dying, would face a real risk on account of the absence of appropriate treatment in the receiving country, or the lack of access to such treatment, of being exposed to a serious, rapid and irreversible decline in his or her state of health, resulting in intense suffering, or to a significant reduction in life expectancy. It is quite a dense paragraph there. So looking at the various components of it, we must have a seriously ill person. So this indicates a chronic condition. There must be then substantial grounds for believing. We'll look at the procedural obligations in a moment, but this is something that the applicant themselves has to raise. They do not need to be at imminent risk of dying. And this is in the country that they're now in. And this is, of course, where it really significantly departs from D. And it must be shown that they would face a real risk. And this is the Refugee Convention standard, the reasonable degree of likelihood, the lower standard of proof. Lord Justice Sedley in Batayav likened that to a 1 in 10 chance. This was then endorsed in the Supreme Court in HJ Iran. Certainly, it's a much, much lower threshold than a 50%. And it must be then on account of, so a causal link there, the absence of appropriate treatment or lack of access to such treatment. So this brings into play theoretical and practical availability. It's not good enough that the treatment is available at a huge cost if this is not something that you are going to be able to access. And the person must be face a real risk of being exposed to a serious, rapid and irreversible decline in their state of health, resulting in intense suffering, or to a significant reduction in life expectancy. Now, what exactly these two, this disjunctive test here, so one or the other will suffice, and what exactly they mean is a topic for consideration, and it's one of the questions that we received beforehand from Mabeka Shiwa. What would this mean, this significant reduction in life expectancy? Well, Lord Wilson in AIM Zimbabwe said that this has to mean substantial, otherwise it would not reach the minimum level of severity which we require for Article 3. He gave an example of a person who was 24 as opposed to a person who was 74. If the life expectancy of both of those persons was reduced to 2 years, then in the case of the 24-year-old, this would be seen as a significant or substantial reduction. It remains to be seen in the future whether anything else apart from a chronological age would be used to indicate what is a significant or substantial reduction. And then exposed to a serious, rapid and irreversible decline. Those three separate standards there. It cannot be something that is slowly happening. It cannot be something that can be reversible. Now, it is raised as to whether mental health illnesses would apply, and they would also be covered under this. And later we'll look at the sovereign judgment of the European Court of Human Rights, which specifically was related to a gentleman with paranoid schizophrenia. The AIM Zimbabwe case was also important because it looked at the procedural requirements that had been set out in Papshevili. So an applicant must adduce evidence before the returning state that's capable of demonstrating that there's substantial grounds for believing that they may face a real risk. Lord Justice Sales in the Court of Appeal described this obligation as having to raise a prima facie case. And Lord Wilson agreed with this in the Supreme Court and added, this means that it's a case which, if not challenged or countered, would establish the infringement. So technically, if you've raised a prima facie case, you've submitted these documents, it may be that your case would be allowed immediately. Then the returning state has to verify on a case-by-case basis whether the care and treatment in the receiving state would in practice be sufficient. So is it actually available to the person geographically in terms of their resources also? And what they need to do is dispel any doubts raised by it. In the Supreme Court, Lord Wilson said that means any serious doubts. In Papshevili, they stated that the assessment of risk would need to take into account general sources such as reports of the WHO, reports of reputable NGOs, and also we need the specific medical certificates concerning that person. So a person will have information and medical certs from the hospital where they're potentially being treated. As I stated before, whether the accessibility is practically there. Now, if there are doubts still persisting, the returning state ought to obtain an individual assurance that the appropriate treatment will be available and accessible to that particular individual. Now, this amounts to really obtaining a memorandum of understanding. As we know, these are not a regular occurrence, and so this may not actually happen in specific cases. And the question then arises as to whether, if a returning state has not obtained a memorandum of understanding and have not obtained these individual assurances, would they be found to have breached Article 3? Well, in Papshevili, there was found to be a failure to discharge the procedural obligations. However, in that case, Georgia had given evidence that they could provide appropriate treatment for his illness, but this was not accepted by the European Court of Human Rights. They said the information was insufficient for the authorities to conclude that he could not have run a real risk of treatment contrary to Article 3. They needed more assurances. And similarly, in Sovereign, a case I'll turn to in a moment, there the European Court of Human Rights found that they had failed to obtain sufficient and individual assurances. And this was Denmark. Now, this was a Turkish national with the diagnosis of paranoid schizophrenia who had settled in Denmark. He'd been there since quite a young age. His family had also all moved there. Now, the evidence before the court was that the drugs he needed were available in Turkey and would be practically available to him as well. They could be supplied free of charge. However, the treating psychiatrist gave evidence to the Danish courts that there were other elements of the package which he required. His medication had to be taken daily, and this meant that he needed a regular contact person and he needed a follow-up scheme for his overall supervision. And this might be something that occurs regularly in cases where it's a mental health condition rather than a physical health condition. The evidence from the consultant psychiatrist was that a potential interruption of the treatment gives rise to a significantly higher risk of offences against the person of others due to a worsening of his psychotic symptoms, and that there was a high risk of pharmaceutical failure and resumed abuse, and consequently worsening of his psychotic symptoms and aggressive behaviour. Interesting that the risk that seems to be forewarned there is of damage and harm to others rather than to Mr. Savran himself. Now, there was no evidence before the courts about the accessibility of a contact person or the follow-up scheme, and they found there was a procedural breach. However, looking at the test set out in Papashvili, the serious, rapid, irreversible decline resulting in intense suffering or a significant reduction in life expectancy, which one of these categories did Mr. Savran fall into? There was no evidence in front of the court that he would face a significant reduction in his life expectancy. The intense suffering or harm, it seems the harm was to be posed to others. While a breach of Article 3 was found, the court was split 4-3, and it has been referred to the Grand Chamber, and it is a little watch this space. Will the Savran Grand Chamber judgment be a backtrack on the Papashvili test, or is it more a factual dispute? Now, the UK government has sought to be an intervener in the case, and I can imagine many states would be seeking not to have the test expanded any further. But what we want is to make sure that it doesn't become contracted. However, looking at the Savran judgment and the dissenting opinions, it would seem to be more a factual dispute whether on the specific circumstances of Mr. Savran, he actually falls into one of those tests. AM Zimbabwe will also return to be remitted. So in the upper tribunal, Lord Wilson has asked that it be a panel composed of the President. And will they flesh out those procedural obligations? They'd already been considered in AXB by the President of the upper tribunal. And Lord Wilson called that a useful analysis, and it might be a case you'd wish to go and read. However, the returning state's obligation to obtain this assurance in AXB, it was pointed out that this is not a freestanding obligation. This is just in relation to the discharging of the burden of proof. And Lord Wilson gave some preliminary indications on the procedural obligations while noting that the case would come back to the Grand Chamber. He said that he could, with some confidence, give some comment. And he said, while it's for the applicant to adduce evidence about their medical condition, the position of the returning state, they're in a better position to collect evidence about the availability and accessibility of the treatment in the receiving state. So for him, the burden needed to shift to them in certain circumstances because it was more practical and they're in a better position to do that. So a recap, the more stringent standard in N no longer applies. So death is no longer required to be imminent. What we need to show is a serious, rapid and irreversible decline in the person's health, resulting in intense suffering, or a significant reduction in life expectancy. And remember, significant reduction will mean substantial reduction and will be context specific. And that treatment needs to be both theoretically and practically available. The applicant must raise the prima facie case, submitting their medical evidence, and the returning state must then hit back and assess on a case-by-case basis and dispel any serious doubts they have. So keep an eye out for the Grand Chamber judgment in Savran and, of course, the AM Zimbabwe judgment back in the upper tribunal. So it has been nearly a month since the case was promulgated. I actually haven't had an opportunity to use it yet, being as we are in lockdown. Things have been a little different. Jake, have you had a chance to put into practice this really wonderful judgment from AM Zimbabwe?
Unfortunately, I haven't yet, mainly for the similar reasons to you raise, the difficult circumstances of lockdown. But I do think it's going to be an incredibly important case moving forward. And I think the key interesting question, as you raise, is on the ground, in what circumstances is the FTT and or the UT going to find that Article 3 is engaged by the return of a specific individual? So I think there's some teasing out to do there. Chelvan, what about yourself?
Well, what I'm really interested in is the linkage between these sort of claims and also protection claims based on disability. Because what AM Zimbabwe allows us to do is that both sides of litigation have to look at the country information with respect to medical treatment. But how is the individual going to be treated on return by the state and non-state agents in relation to their condition? So, for example, the 2017 API on sexual orientation issues in asylum claims has a bullet point on page 16 regarding discrimination amounting to persecution. It's a non-exhaustive list looking at legal measures, social measures, private rights, other rights which are going to be expressed. Knowing that the threshold, the standard of proof is lower for Article 3 and persecution than it is for Article 8, what I'd be looking to see is how we can also run these claims in tandem with protection claims for migrants in relation to risk assessment. Because there's currently no reported cases on disability and protection claims. I'm instructing on a case at the moment going through the upper tribunal. Hopefully that will be reported. But it's very important to look at this as another area in relation to migrant protection.
Okay, great. Thanks, Chelvan. That's another interesting little angle from the AM Zimbabwe judgment. I'm going to hand over now to Jake, who will bring us through Article 8.
Thanks, Avril. Much appreciated. Yes, so the ultimate question to be asked in my presentation today is, are we reaching the end game on the interpretation of Article 8? Now, the headline to this slide really says it all, and now the floodgates will open. Because in 2014, by Section 19 of that year's Immigration Act, we had the insertion of Sections 117A to D of the Nationality, Immigration and Asylum Act that you've all had time to grapple with now, and that's reflected also in the jurisprudence. As you'll know, what Sections 117A to D did was essentially to try and provide a statutory codification of what is required in the public interest. You have general provisions in Section 117B applying to all cases in which an Article 8 claim is raised. And then you also have the specific provisions for cases involving the deportation of foreign criminals in Section 117C. Now, the floodgates were certainly opened, and we've had a cavalcade of jurisprudence on how those sections are to be interpreted. And much to my eternal dismay, I said, yes, of course I'll do a talk on Article 8. It's very interesting. I only did one 7 months ago. There can't be much since, can there? I was incredibly wrong, and I ended up with a lever arch full of case law that's arisen since then. But what I'm going to do is give you a brief selection, or as I explain here, a whistle-stop tour of some of the more interesting jurisprudence, and then bring us together at the end with, just to bring back memories of law school, a list of further reading, which I think would also be helpful moving forward. But to start off with, in my whistle-stop tour, we have the case of GM Sri Lanka from the Court of Appeal late last year. And both temporally, it's the first in my list of cases, but also I think it's a very good introduction to Article 8 for the uninitiated. So it has both helpful points of substance and procedure which are worth addressing. And in terms of the procedure, well, first of all, there's an incredibly important point here that even if, when you get to the Court of Appeal, or even when you get to the upper tribunal, if there was no error of law applying the law as it stood when the first decision was made, that doesn't necessarily mean it's the end of the story, because applying their obligation in Section 6 of the Human Rights Act to interpret and apply the European Convention on Human Rights insofar as it's brought into domestic law, the Court of Appeal and/or the UT must apply the law as it stands when they are considering the case. Why is that so important? Well, it's so important in these circumstances precisely for the list of cases that I've just given you and the list of cases to come, because the law's moving so quickly in this area. So when GM Sri Lanka got to the Court of Appeal, the court observed, well, there wasn't an error of law at either time when the FTT or the UT made their decisions, but at that point we didn't have, and it gave a list of cases such as KO Nigeria that we all know and perhaps love moving forward. So that's a very key point. The second part of GM Sri Lanka is, of course, the substance. And just to put this in context, it wasn't a deportation case. It was a case whereby when you were at the first tier tribunal and the upper tribunal, there was one set of facts. And then prior to reaching the Court of Appeal, the husband of the appellant and their 2 British citizen children were both granted indefinite leave to remain. And that's where this first bullet point comes in here, because a proportionality analysis under Article 8.2 requires consideration of what rights the family members of the appellant might have to relinquish if leaving with the appellant. So here you had 3 individuals with ILR, and they were going to have to relinquish certain rights if they were to be returned with the appellant. The second point, quite often forgot, but very important to remember, sections 117B 4 to 5 of the Nationality, Immigration and Asylum Act don't apply to consideration of family life. And the court at paragraph 38 threw back to Rupiah for this proposition. It's essentially only looking at private life when you are applying those 2 subsections. The next point, insurmountable obstacles to family life continuing outside the UK. Well, that's contained in the rules, but it only amounts to a freestanding prima facie test, because even residents in breach of the rules can found an Article 8 claim in exceptional circumstances. But of course, we know that exceptional circumstances doesn't mean searching for that golden nugget that makes this case so different to any others. It's just a proportionality analysis. Fourth point, it's not a mechanistic ability or capability test when you look at whether someone could return to their state of nationality. It's a fact-sensitive test looking at all the circumstances, not just whether physically they could move. And then finally, and quite interesting, solely on the basis of what generally happens on a day-to-day basis in the tribunals, is it's said that comparator cases are of limited utility. Why is that interesting? Because anyone who's stepped foot in a tribunal over the last year or so and has had an Article 8 case will know just how much presenting officers like to break out PG Jamaica and to say, well, if it wasn't unduly harsh in this case, how can it be unduly harsh in your case? So the Court of Appeal in GM Sri Lanka makes it clear that that is in fact an exercise of limited utility. You've got to look at all the facts of the case. Now, Patel, British citizen child, deportation, a deportation case, as the name suggests. This concerned the interpretation of section 117C5, which, as you'll remember, is exception 2 to the public interest when you look at a foreign criminal as defined who hasn't been sentenced to a period of imprisonment of 4 years or more, but less than 4 years. And when you look at the provision, what is reminded to us by the upper tribunal in Patel is that it's a two-stage analysis. You're looking at both whether it would be unduly harsh for the child to leave the UK with the parent who's being returned, or should I say, and whether it would be unduly harsh for the child to remain in the UK without the parent who's being returned. And what the upper tribunal said is both require analysis of this hypothetical question of whether going or staying would be unduly harsh. You're not having to predict whether or not a child would in fact leave or would in fact stay. And then the nugget in this case is that British citizenship is a relevant, though not necessarily weighty factor in the assessment whether going or staying would be unduly harsh. And there's analysis in the decision of the upper tribunal of the rights and responsibilities that apply to British citizenship or flow from British citizenship, and how that might affect the proportionality analysis. Now, Imran is also a deportation case. It's a section 117C5 case, but what I also note, both in Imran and in Patel before it, is they're also 117C6 cases, which is where you have to show that there are very compelling circumstances over and above those described in exceptions 1 and 2. Now, yes, that applies to those foreign criminals who are sentenced to a period of imprisonment of at least 4 years, but as we know from RA section 117C unduly harsh from the upper tribunal last year, that provision also applies as a fallback in all foreign national criminal cases. So in this case, it further highlights the high bar that's required for a finding that the effect of deportation on their partner or child would be unduly harsh, as the upper tribunal have stressed on multiple occasions in the past year or so. And specifically, what it's said is that the unduly harsh test won't be satisfied in a case where a child has two parents by either or both of the following without more. So they're relevant factors, but they won't necessarily be enough on their own. Number one, evidence of the particular importance of one parent in the lives of the children. And two, evidence of the emotional dependence of that child on that parent and the emotional harm that would likely to flow from separation. So this is your paradigmatic case whereby you have one parent, perhaps the mother, who goes out to work and the father stays at home, potentially from restrictions on being able to work, stays at home with the child and therefore develops a unique parental bond. So the fact that there's that evidence of emotional dependence above and beyond what you might ordinarily see is not necessarily enough on its own. Now, Bucci is a great case. Bucci is a common sense case which is somewhat affirming because it affirms a principle that I've been trying to run as a matter of logic for some time now. And that is, just because you don't meet the definition of partner in Gen 1.2 of the immigration rules, it doesn't stop you from being considered a partner under sections 117A to D of the NIAA in the broader proportionality analysis outside the rules which would follow. Now, it was put in signing up by Vinita Templeman. Could you help out with any deportation and Article 8 cases as they relate to young adults? Now, this is the most prominent case that I've come across over the past year or so dealing with young adults and deportation. Because in this case, what you had was an appellant who was born in 1999, brought to the UK at the age of 7. An asylum claim was rejected, but he was granted leave to remain from 2014 to 2016 as a UASC. You had then a detention and training order imposed on him for possession of Class A drugs with intent to supply. And then you also had 3 years imprisonment for conspiracy to supply Class A drugs. Deportation order made, appeal against that after submissions of the HR claim were dismissed. Now, the ultimate question, as I've indicated, is the relationship between the definition of partner in the immigration rules and also the use of a partner, a qualifying partner, in the sections 117A to D. The logic was this. The upper tribunal said, if you meet the definition of partner in the rules, you're also a partner under sections 117. If you don't, then the judge needs to conduct a broad evaluative assessment of that relationship. And a bit of guidance was given. So a partner is a person to whom one has genuine emotional attachment of the same basic kind as one sees between spouses and civil partners, albeit not necessarily characterised by present cohabitation. And that final clause there reflects the fact that this definition of partner is wider than that provided in Gen 1.2 of the rules. On the other hand, a partner is not the same as a friend, nor is an adolescent's or other young person's boyfriend or girlfriend necessarily a partner. And that was important in this case because one of the witnesses was B. She was a British citizen. She described herself as becoming good friends with the appellant in 2016. They began a committed relationship. They would be, in their words, always be together, going on dates and meeting up in 2017. They didn't live together, but they stayed at each other's homes. And in June 2017, the appellant bought her a promise ring. In her evidence, she said, I stuck by him throughout the period of remand in custody, and they had discussed their future plans, including living together, marriage, starting a family, love's young dream. Now, the upper tribunal held in this case that by a narrow margin, there was a relationship of sufficient commitment to make B the appellant's partner for the purposes of Part 5A. But what's the impact of being a partner under those subsections? Well, looking at section 117C5, unduly harsh, where the partners have only recently met and are not cohabiting, it's generally far less likely to generate unduly harsh consequences for the remaining partner than a long-standing relationship with significant cohabitation. On the other hand, what's the result of not being a partner? Well, it still remains necessary, section 117C6, to consider the deportation on that other person, examining the substance of the relationship. So my brief analysis there, it's not a bright line between the two, and it reflects the earlier jurisprudence of how 117C6 will be almost a fallback position, even in terms of those foreign national criminals who have not committed offences with a sentence of greater than 4 years. Now, one thing I will flag just before hitting Adine is there's been a lot of use of the term foreign criminal in my presentation so far. Mike Pultner very kindly and very helpfully flagged that the upper tribunal at the moment is considering the issue of how do you define foreign criminal by reference to competing case law so far. Thank you very much, Mike, and I flag that for everyone's interest moving forward. Unfortunately, I checked this morning and we still don't have that yet. So, Adine, when will Article 8 be engaged by family life in the specific context of a foster family? Does it make a difference if it's a foster family or if it's a biological family? Principles established in this case. Of course, we all know Kagathas. The test is one of effective, real or committed support, and there's no requirement to prove exceptional dependency. Nothing particularly new there, reaffirming old principles. Second point, the test isn't different within the foster care context. So there's no significant determinative weight to be given to the fact that a foster arrangement has a sense of formal commerciality. So you strip that aside, it is a relevant factor by the analysis of the Court of Appeal, but it doesn't get significant determinate weight. And thirdly, particularly helpful in the context of young persons, there's a continued existence of family life after the attainment of majority in certain cases. It's a relevant question of fact. There's no negative inference from the mere attainment of majority. And if you have continuing cohabitation with your biological or foster family, that is suggestive of the ongoing real, effective and committed support in the Cogathas sense. Two other very helpful points. First of all, taking a leaf out of criminal practitioners' books, Lucas directions. Just because you lie on one matter, it doesn't necessarily mean that you're lying on other matters. And I apologise to my criminal colleagues for butchering that, the idea of a Lucas direction, but I hope you get the gist. We've had previous case law suggesting Lucas directions are helpful in family law. We now also know that Lucas directions extend to immigration appeals, thanks Court of Appeal. And finally, it's a point that's often raised by presenting officers and also judges when you get to the stage of the upper tribunal. And they'll say, Mr. Rylatt, you're saying here that the first-tier tribunal judge has failed to apply Tanvir Ahmed and the basic principles contained therein. I'll say yes. They'll say, well, this is a very experienced judge, isn't it? You know, can we assume that they've made that error? Well, the Court of Appeal reminded us all in Udine that we're all human, barristers, solicitors, legal executives, judges, everyone. So there's no assumption on appeal that experienced judges should not be expected to make a mistake. Now, Eunice, and we're coming down the home stretch now, 2 cases to go. Eunice is a case which is in some ways a useful taking stock judgment on family life applications. It looks at the best interests of the child, it looks at the interpretation of section 117B, and it conducts a balance sheet analysis, as we know from the Supreme Court is a helpful tool in the armoury of tribunals. But it addresses 2 specific issues in the context of temporary removal cases, post-dating Part 5A of the Nationality, Immigration and Asylum Act coming into force. And by temporary removal, what do we mean? We mean where the appellant would in fact only be required to leave the UK for a limited period of time in order to apply for entry clearance to return to the UK to join their partner and or child. Now, 2 specific issues arising. First of all, what's the effect of Chikwamba in these circumstances? Well, the fact that the appellant would succeed in an application for entry clearance does not obviate the need for an assessment of proportionality. And secondly, thinking about Zambrano rights under the EU regime, where the child is very young, the tribunal raised the question of whether the child would in fact engage in any of the activities where her EU rights are relevant during a period of temporary removal. And that is quite a novel point, and I'd be very surprised if there isn't an appeal already underway analysing that. And that's specifically so when you consider that the upper tribunal followed that paragraph by stating, this, to our knowledge, hasn't been considered in any European or any UK cases. So, pin in that, watch this space. And finally, Rushe is a very recent case from the Court of Appeal, Lord Justice Singh. And I've been back and forth in my mind on this as to whether it is so-called appellant-friendly, respondent-friendly, somewhere in the middle. And I think I'd implore you to go away, read it, see what you think, because it is an important case, but I think it can be quite divisive as to how you read it. So it's one definitely to know. It could be the next PG Jamaica. Now, what happened in this case was there was a submission rejected that section 117b6, so dealing with the public interest in removal, where a person has a genuine and subsisting relationship, parental relationship with a qualifying child, and it wouldn't be reasonable to expect the child to leave the UK. And it said this doesn't lay down a categorical or hypothetical approach, i.e., where one of the parents of the qualifying child has a right to remain in the UK, it cannot be reasonable to expect the child to leave. That is not the approach to be taken under 117b6. Now, it then drew this distinction between a conventional proportionality assessment, by which I understand on my reading to be a general Article 8.2 assessment without reference to the regime in 117b6, and then 117b6 assessments. The relationship was, if you win on 117b6, then you don't need to go on to consider Article 8.2 generally, because 117b6 is not quite a self-contained regime, but it is definitive if you win on that point. But if you lose on 117b6, then you have the backup position of a general proportionality analysis under Article 8.2. Finally, and one of the reasons why I've been back and forth in my mind on this is because Lord Justice Singh states, reasonable to leave. It's not a hypothetical question, but it's a normative question. Now, normative is a word of many meanings in many different contexts, and it does, in my view, flag a spectre of doubt as to what precisely the Court of Appeal were aiming for in using that term. There's also a question as to whether it's consistent with UNIS, which we've previously discussed. So I'll leave that one for you to mull over moving forward. Now, finally, reaching the end game? Unlikely. The Upper Tribunal and the Court of Appeal are handing down judgments almost simultaneously, and that appears to be causing some difficulty. So, for example, in Rushe, Lord Justice Singh didn't have the benefit of UNIS, hadn't been released yet. Udine was not cited in his judgment, but perhaps it was cited in argument, that was only released 1 week before the hearing in Rushe. So you have to be very up to date with these matters. You do see that certain concepts are starting to crystallise, and as I say, it's incredibly important to keep on top of the jurisprudence, and with an incredibly shameless plug, we are here to help in that regard. Now, as promised, further reading. These are the also-rans, the nearly made it, but also interesting in their own right. And finally, I note, watch out, RA Iraq and SSHD back to the Court of Appeal after a previous run in 2019. 3 of our barristers at number 5 on that, dealing with the issue of limbo. Thank you very much for listening.
Thank you very much, Jake, for that wonderful summary of the pathways in relation to Article 8 and deportation. I was very interested in Mike's question in relation to foreign criminal. I've got a case at the moment where the individual was born in the UK, has a Jamaican national mother, but because an individual needs to apply for citizenship to be able to obtain Jamaican nationality, even if they have parents through descent in relation to nationality, the individual has no nationality at the moment. So where the Home Office has been very much publicly talking about deporting foreign nationals, that's an area of the law which also needs to be looked at as well. So moving now on to practice and procedure, we know that within the Upper Tribunal from the 1st of June, Fieldhouse in London is expecting to hear oral renewal permission hearings from the 1st of June in relation to remote hearings in Fieldhouse, and also substantive hearings as well. 3 cases a day in the courtroom, up to 45 a week. Now that raises all sorts of procedural issues. Arguably, if it's an error of law hearing only, and it's only in issues of law, they could go ahead. But the problem here with respect to those sort of issues is in relation to access to justice. What happens if the migrant, £35 a week if you're an asylum seeker, doesn't have the technology to be able to link in to the hearing, and especially where the individual would need to give evidence, clearly it would be against the interests of justice, or even the rights of the individual to have that hearing done remotely. I know that Samir Pasha and Naga Kandia have written an article on remote hearings in the New Jurist, which was published recently. The link to that article will go in the chat room soon. Avril, what's your views about remote hearings in the first year tribunal?
Well, certainly if we have appellants who are giving evidence, I don't think it would be appropriate. You miss out on all of the verbal cues. And obviously when these are cases that turn on credibility, I feel it would be really detrimental to our appellants' best interests. And then added in the issue of interpreters, which at the best of times can pose difficulties. I see that Hatton Cross have some proposals out there that maybe hearings could start to resume there. So using alternative courtrooms and then using waiting rooms for social distancing. Unclear how this will work in practice, and whether we'd be able to have an area where you could properly take instructions from your client in a way that really respects the gravity of what's being discussed.
And then, just from my perspective, because I haven't thrown enough case law at you so far, there's just one more procedural update, which I think you will thank me for. Maybe not now, but maybe later. A case called Birch, Precariousness and Mistake, New Matters, one of this year's in the upper tribunal. And it's very helpful simply because it says, when you get to the upper tribunal, the strictures of raising new matters, as contained in sections 84, 85 of the NIAA, come off. And therefore you can raise new matters, assuming you jump the hurdle of finding an error of law, you can raise new matters within the upper tribunal without having to have the Home Office's consent.
Oh, wonderful. Well, now let's move to some questions which may have come up in the chat room. Avril, anything for me?
Chelvan, there's one, it specifically relates to Trinidad and Tobago. So it's from Shingai Mahumbo. Why are LGBT claims from Trinidad and Tobago being refused?
Well, what's quite interesting, in the last couple of years, there was a huge landmark decision by the High Court in Trinidad striking down the anti-sodomy legislation in Trinidad and Tobago, which was, heralded globally as a complete change in relation to the positions and plight of LGBT individuals. But we also know that even though laws may be decriminalised, and there are appeals going on, is that the issues regarding non-state agents and protection. The Home Office don't have a published CPIN on Trinidad and Tobago. That doesn't mean that they don't have that sort of material. I did write about the Home Office CPIN in relation to SOGI, and that's going into the IGCI report, which is being published in September. But looking at the situation on the ground, don't just look at the decriminalisation, but also look at the issues regarding non-state agent harm and lack of effective protection. I hope that answers your question, Sim.
Avril, here's one from Senan. Does it make a difference to the procedural requirements of Article 3 whether a person is being returned to another contracting state, like Georgia, or to Uganda, for example?
So in Popshvili, that was Georgia. So it was one EU country, one ECHR country removing to another ECHR country. In Popshvili, the Grand Chamber said that that's not decisive. So there is obviously a presumption that there will be treatment that is not contrary to Article 3 in contracting states. But if you have raised your prima facie case, then that would be rebutting that presumption. And then the obligations on the returning state will be the exact same. So it won't matter then if you're returning someone from the UK to Ireland or you're returning from the UK to Uganda. Once the prima facie case has been raised, it's kind of similar to in MSS and Belgium and Greece. Their questions were raised as to whether the appropriate remedy would not have been for the person to actually just raise the complaint in Greece against Greece, but Belgium was still found to be to have their duty under Article 3. So no, is the short answer. It doesn't make a difference.
Great. And Jake, hot off the press from Carmen, if an AE national makes an in-country appeal to revoke a deportation order, raising EA and Article 8, and have an in-country appeal on Article 8 only, do they have an out-of-country appeal right on the EA matter or no appeal? If the EA regs state an application to revoke deportation order on EU law can only be made from abroad. And you have 2 minutes.
Thank you, Chelvan. I saw this come up in the chat, and it's a really interesting question. And I've been trying to almost preempt and think this through in the background, so I'm glad that you asked me this one. But it seems somewhat artificial to carve out part of an appeal and say you either have only an out-of-country appeal or no appeal on this part of your claim, but on the Article 8 point, you've got an in-country right of appeal. It's something that I would want to consider further, but my instinct on this is that you'd consider both of them together as part of the in-country right of appeal. Though, if, of course, you wish to discuss that further, I'm sure that we can get our collective hive mind together and provide some assistance.
Wonderful. Thank you very much, Jake. And if everyone wants to come back online, this concludes the webinar today. Thank you all very much for linking in today and listening to the various presentations in relation to new pathways and approaches. There will be a feedback form which is being sent through a SurveyMonkey following this presentation this morning. Please do contribute. We want to know how you felt this first ever Migrant Law Clinic webinar came across to you, whether there are any new ideas for presentations which we can do in the future. I'd like to personally thank on behalf of Avril and Jake and I, the marketing team, especially Erin and Penny, for all the amazing work and support they've put into helping us produce this webinar this morning, and our Senior Practice Director, Abdul Hafiz, and our clerking team, Gavin John, Christy Irvin, and Lucas Burnett, and of course, Jeff Carr, our Director of Clerking in London. So we started the webinar with a question: what 3 favourite words? Well, let's end the webinar with 3 words we wish to share with you. Please keep safe. So it's goodbye from me.
Thanks very much. Goodbye from me.
And it's goodbye from me.
Goodbye.